Good afternoon, everyone. Thank you for joining us. I am just going to get started with an introduction while everyone in the waiting room starts to join the call. It looks like slowly people are being brought in. So, you know, we're grateful that you're joining us today. A lot of this is surrounding the science of reading and the new requirements in Wisconsin. If you signed up for this, you probably know that this particular presentation is specific to the policy on promoting children to fourth grade or holding them back in third grade. What does that policy look like? And today we want to talk to you both about what is required by law and what is a best practice. There's also obviously a Wisconsin Supreme Court decision that came out yesterday, so we will be discussing that as well. And for anyone who I have not yet met, I saw some new names on the registration list. My name's Corey Brewer. I serve as Education Counsel here at Will, and that means that I work on a variety of K through 12 education legal and policy projects. And those are from public school reform to supporting educational choice to parental rights and anything kind of in the K-12 context. And Lauren, do you want to introduce yourself? Or you're on
Yes.
mute, I'm
No,
sorry.
sorry, it's okay. My name is Lauren Groyle. I am Associate Counsel here at the Wisconsin Institute for Law and Liberty. I work very closely with Corey on K through 12 litigation and policy issues. I'm happy to join today to talk about some of these Act 20 requirements.
And then just real briefly about Will. We're a nonprofit 501c3 law and policy center based here in Milwaukee, Wisconsin. Through education, litigation, and participation in the public discourse, we work to advance limited government, free speech, transparency, and education reform. And as I had mentioned today, just so you have a general idea of what we plan to go over, we will go through the legal obligations under Act 20 specifically for this promotion policy requirement, some best practices, recommendations beyond those legal requirements, and then a discussion about the Wisconsin Supreme Court decision from yesterday and how that will affect Act 20 requirements. And then we'll save time as much as possible for Q&A. And I will mention before I get into the substance of the presentation that if anyone has questions, feel free to use the Q&A function at the bottom of your screen at any time throughout the presentation and ask us questions. And I want to mention too that, especially for my part, I'm going to be going through the legal requirements and what the statutes say fairly quickly. So if there's anything you feel you're missing, obviously you'll be able to go back to these slides. This presentation is being recorded, but perhaps even better than that, we have two new guides out, or I should say a model policy and a guide. So both of these are available at schoolboardpolicies.org. And the first is a model policy on determination or promotion or retention of students with personal reading plans. And then the second is an implementation guide that kind of expands upon and we try to make it easy to understand, easy to implement, and explain how this works and why it's important as well. And if you're a Wisconsin school board member who's joining us today, the deadline, as I'll mention, to have that policy in place is July 1st. So probably most of you already do have a policy in place to comply with the law, but I will mention if there's anything, if you like our policy, if there's anything in our policy that you think, oh, I would really like to add that, there's nothing stopping you from going back to change or revise or add to the policy that you have in place. Because obviously all of this is working towards helping children read and helping with their proficiency so that they can learn and be set up for success. So if you see anything that you think might be helpful, and we think it is, otherwise we would not have put this out for you all, please do consider adding it or revising your policies accordingly. Now, all of this, where does it come from? 2023 Wisconsin Act 20. And you probably heard a lot about this law and what it requires. And you've seen probably other versions of model policies, maybe ours, but we want to go through the actual legal obligations so that you can see, okay, I've heard all of these things, where are they coming from? And then we're going to talk about our resources, best practices. And on my slides in particular, I have some text included from Wisconsin law directly. So I'm excited to go through this with you all today. And of course, we want to start with kind of the bedrock of it all, required early reading instruction. This is Wisconsin statute 118.015, and it's a bit small on your screen here, but you'll see that it indicates the purpose and intent of this law is to provide for a developmental reading program for all pupils at all grade levels. So that's kind of high level, the intent of the law. And I will mention too, this ties directly to the science of reading movement, which emphasizes instruction grounded in early research. So importantly, Act 20 prohibits the use of 3 cueing strategies in reading instruction. We're not going to dive into that part of the law today, but it's worth noting that this is part of that same legislative action toward evidence-based reading practices, as you all are likely aware. So the bottom line is, not just any literacy program will meet this requirement. Instruction must be aligned with the science of reading and must avoid practices that have shown to be ineffective. Now turning to the promotion policy requirement. Where you'll find this in our state law is 118.33 subsection 6, subsection A, subsection 3. And it indicates that every school board must adopt a written policy that explains the criteria students must meet to be promoted from 3rd grade to 4th grade. And this policy, as I had mentioned earlier, it has to be adopted by July 1st, 2025. So next Tuesday, if you're watching this live. Then, beginning on September 1st, 2027, that policy becomes enforceable. If a student doesn't meet the board's promotion criteria, they may not be promoted to 4th grade. So at that point, it's not a suggestion, it's not a recommendation, it is a legal requirement that districts must follow. And then the next aspect of the law is regarding universal screenings, at-risk designation. If you happen to take a look at this law, and we have this in our model policy as well, there are many definitions, a lot of definitions to be aware of. And I have 2 of them, the key definitions up on the screen now. So under Wisconsin statute 118.0161A, a student is considered at risk if they score below the 25th percentile on a universal screening assessment or a diagnostic assessment as indicated by the publisher of the assessment. The law also defines what qualifies as a universal screening assessment. The screener must evaluate a student's skills in all 5 of the following foundational areas: phonemic awareness, decoding skills, alphabet knowledge, letter sound knowledge, and oral vocabulary. These are obviously essential building blocks for reading success, especially in those early grades. And importantly, the Department of Public Instruction, DPI, they require districts to use something called Ames Web Plus as the universal screening assessment. We also have that detail in our resources. Now, the next 2 slides, I will admit, these have a lot of text on them. So I just really want to provide an overview about parent notification because it is a requirement under the law. And obviously, in order to kind of foster that student success, you want to encourage parent involvement and encourage it early so that parents know how their kids are doing. So if a student is identified as being at risk, then the law says, okay, here are your next steps. Under Wisconsin statute 118.016 again, subsection 4, the school must notify the student's parent or guardian within 15 days of the screening or diagnostic results. And that notification must be in writing, and it must include very specific categories. So you can go to any of our resources to take a look at those. Examples are the students' test results, what those results mean, and what steps are going to be taken next. And then here's a little bit more on parent notification, just to make you aware of what's in the law. There's a few different subsections on special education information, dyslexia information for certain students, and early literacy remediation plan. So just a few other things that are in that parent notification section. Now here's another key part of the law, personal reading plans. We'll turn to this next. Under Wisconsin statute, here we are in the same section again, 118.016 subsection 5 now. If a student in 5K through 3rd grade is identified as at risk, the school must create a personal reading plan for that student. And our state law indicates what should be in that personal reading plan. It's also spelled out in the WIL model policy and implementation guide. Just a few things to highlight. A personal reading plan has to include what are the students' specific reading deficiencies, what are going to be some goals or benchmarks for progress for that student, a plan for how that progress will be monitored, description of the interventions and services the student will receive, the specific science-based instruction the teacher will use, suggestions for how the parent can support reading at home, and any additional services that could help accelerate the student's progress. And then I will mention too, you can see at the bottom of this slide that after 10 weeks of interventions, then that parent notification is triggered again. You have to let the parents know how their student is doing after 10 weeks of interventions. The next topic is support for students on a personal reading plan. So if a student is still promoted to the next grade despite being on a personal reading plan, the district has continuing responsibilities to support that student. Under Wisconsin statute 118.33, subsection 5M, subsection A, the district must provide that student with intensive instructional services, ongoing progress monitoring, additional supports to address the specific reading challenges, and an intensive summer reading program every summer until the student scores at grade level. Okay, next, there are some exceptions to this, as you might imagine. The law provides for what is called a good cause exception, and this is really important. A student can be promoted to 4th grade even if they haven't completed their personal reading plan, if they meet one of the good cause exceptions outlined in the statute. And these I will go through just so that you're aware of what they are. As you can see here, limited English proficient students, a student who has an IEP, and they would have to indicate that neither taking the exam nor taking the assessments is appropriate for that student with the IEP. A student who scores as proficient in reading on an alternative standardized assessment approved by the department. And then there's a few more on the next slide. A student with an IEP or a services plan under section 504 that indicates that that student has received intensive intervention in reading for more than 2 years. If that student continues to demonstrate a deficiency in reading and was previously retained in kindergarten, 1st, 2nd, or 3rd grade. And then that last good cause exception is for a student who has received intensive intervention in reading for 2 or more years, continues to demonstrate a deficiency in reading, and was previously retained. And then this here, you can see the ellipses at the bottom of the screen. There are more requirements than this. So I will disclaimer right now, what you see on the slide is not all that there is. However, if you go to section 118.016 subsection 7, or if you look at either of the WIL resources, we list out all of the DPI reporting requirements, and I won't go through all of those today, but I want to make school board members aware that beginning on July 15th, 2025, and each July 15th thereafter, the board must submit a report to DPI for each school and for the school district for all of the following. And it's listed in our state law and in our resources, as I had mentioned. It has to include things such as the number of students screened, identified at risk, that school year, the previous school year, how many were placed on personal reading plans, and what that improvement looked like. But I would refer you to our resources or the state law for more of those details. Obviously, this annual report will help the state monitor both compliance and outcomes over time. And detailed reporting requirements are available for you online and in our resources. All right, and I will wrap up my part of the presentation now on the next two slides and then turn it over to Lauren. Just an overview then of the key deadlines. July 1st of this year, you have to have a written promotion policy in place. July 15th, that first annual report is due to DPI. And September 1st, 2027, that is when the retention requirement takes effect. So students who don't meet the board's criteria at that time cannot be promoted. And next steps, just an overview here. Ensure that science-based instruction is happening in every single classroom. Obviously, this is a shift, and it will take some time, but it is so important, especially since we know now there are certain methods of teaching that are not effective for teaching children to learn in the early grades. Next, make sure the screening and diagnostic assessments are compliant with Wisconsin law and implemented. I think that's key. It's one thing to have a policy in place. It's another to actually implement that policy, put these personal reading plans in place, keep the parents involved, and all of that is so key to seeing success. Develop a promotion policy that meets legal requirements, and prepare to communicate early with parents. So those are kind of an overview. I know I went through that very quickly, but that's an overview of the legal requirements for this promotion policy piece. And then Lauren will talk a little bit more about what else is in our model policy and some best practices.
Yes, thank you so much, Corey. So now that we've gone over what statute requires schools to include in their Act 20 promotion and retention policy, I'm going to go over some of the best practices that your school can implement to ensure ongoing compliance with the statute, as well as how to get the most out of this policy. Will collaborated with several different groups to ensure that what I'm going to go over here, some of these best practices, are effective and will be helpful for implementing Act 20 in your school. So I'm on the screen here, you can kind of see what I'm going to go over here. We're going to talk about multi-tiered systems of supports, evidence-based criteria for determining whether to promote or retain a student in third grade with a personal reading plan, a timeline for schools to implement that both corresponds with statute as well as sets additional deadlines so that parents and schools can have a good expectation of when these things should be occurring, and then an appeal of the recommendation process. As Corey and I have drafted policies, and we have 39 now available on our Will website, it has become clear that it's good to have an appeal of recommendation process in different areas in your policy so that there is kind of a grievance process for parents to go through. So I will start with the multi-tiered systems of supports. So part of the idea for MTSS, and I'm sure a lot of schools have MTSS implemented in one way or another in their districts. It's becoming increasingly popular. I want to talk, though, about the Mississippi Miracle. So, reading proficiency in the state of Mississippi has jumped over 10 percentage points since they enacted a new reading law, which is similar to Act 20. And one of the key components of this law is ensuring that every student is receiving supports and then supports increase as the tiers increase as well. So Mississippi bases part of their success on this MTSS system. On the screen, you can kind of see how they set up their supports in Mississippi for early literacy. In Will's policy now, you can see on the screen, we have 3 tiers. The first tier is for all students. It ensures that um, this is every student in the district receiving evidence-based phonics, um, early literacy education. Tier 2 is more of a targeted approach for students who are at risk and put on personal reading plans. And then Tier 3 delivers more of an intensive, individualized intervention for students who do not make adequate progress in Tier 2. And then this is also where if students are being considered for retention, they would be a Tier 3 student. Another best practice that we want to implement in our policy is what type of criteria you're actually including in the criteria you need to adopt for the promotion and retention of students in 3rd grade on a personal reading plan. So you can see on the screen here that Will has actually put out an analysis on what should be the basis for a decision to promote or retain a student. You can see the policy brief on the screen here, as well as the link to that policy screen. And I just want to mention as well that as of 2020, 17 states actually require students in 3rd grade who are not meeting certain levels of proficiency in reading to be retained. That is not the case in Wisconsin. Act 20 gives schools the ability to establish criteria to determine when these students are promoted or retained, as opposed to just a blanket, if they don't meet a score, then they have to be retained. But this is exactly why this Act 20 policy requirement exists for schools and why you need to establish criteria in the first place. The good news is the law gives schools a lot of flexibility in choosing that criteria. The bad news is the law does not provide a lot of guidance on how exactly and what exactly that criteria should be. So I just want to kind of go over some of the other available model policies out there. It was part of Act 20 that DPI must release a model policy on Act 20 promotion and retention policies. And you can see on the screen here the 4 things that DPI recommends that schools consider when promoting or retaining a student. That is all of the relevant data, whether the student is eligible for a good cause exception, long-term risks of retention and alternatives to retention. So that doesn't give schools a lot to work with either. Okay, you consider the data, you consider whether or not it's a good idea to retain a student, but that's pretty much it. So I will also show you this is Neola's model policy for Act 20. As you can see, they have a bit more, their criteria is a little bit more robust, but it still isn't enough in our opinion. So this talks about things like the best interest of the student, relevant data again, why a student has not completed their personal reading plan, alternatives to retention, long-term risks to retention, and whether or not they're eligible for an exception. Also, at the bottom of the screen here, you'll see that in the policy, it says that the criteria is supposed to help determine whether or not a student should be promoted or retained, and that process will consider relevant factors such as reading proficiency, social and emotional development, and available supports. Those 3 things are not necessarily all in the criteria then that you see on the screen as well for promotion and retention, but it begs the question, does this policy mean that you will be considering the child's social emotional welfare when determining whether or not they are reading at proficiency in third grade? And also, can you promote or retain a student based on the staff that's available? Neither of those things, again, are talked about explicitly in the criteria, but they are talked about in the kind of preamble section of the Neola policy. So again, it's just kind of confusing, these policies that have put out. They're not very robust in terms of their criteria. They don't provide a lot of guidance for schools. And as Corey's already gone over, the statute doesn't provide a lot of guidance either. So it's important to have evidence-based criteria, and that's exactly what's included in Will's model policy. So we actually list out 14 different criteria that considers things like test scores, individual progress, the opinions of teachers, how students are doing in other classes. And it lays out a whole process so that you don't have to come up with this on your own and then put that in your handbook, which is something that DPI's policy refers to as well. And we really want to be sure here that evidence-based criteria, objective criteria is what's being included, as well as some of, like I mentioned, the opinions of the teachers, the opinions of the parents. Because if you're not basing this promotion or retention decision on those things, then there's going to be disputes later on with parents or schools about whether or not to retain a student. So the more robust your criteria can be, the more clear-cut your criteria can be, the less likely it will be that you have issues later on with this determination process when this becomes a hard and fast law September 1st of 2027. Another best practice that's included in Will's model policy is a timeline. So, as Corey mentioned, there are certain statutory deadlines that are met, including when screenings need to occur, when students need to be put on personal reading plans, when parents need to be notified. But Will's policy takes it a step further to implement best practice, which is to have a deadline for every step of the way. So this talks about tier 3 placement and when a student is supposed to be put on tier 3. An initial promotion and retention meeting, when is that supposed to happen? That's not something that's a hard and fast deadline in state statute. Parent receipt of the recommendation, putting a student on a summer reading program, a reevaluation deadline to give students kind of one last opportunity to catch up over the summer using an intensive summer reading program. So again, it's a combination, this timeline, of statutory requirements as well as best practices to ensure that everybody is on the same page about what's supposed to happen and when it's supposed to happen. And then finally, I've alluded to this a couple times, but Will's model policy also includes an appeal of recommendation process. We have received several different communications from both schools and parents about disputes on retention or promotion. And that's something that's really difficult, really frustrating, and it's a sensitive process. So we want to ensure that everybody has an opportunity to make sure that their voices are heard, but that there's still a final decision at the end of the day, which is why we lay out this appeal of recommendation process, so that even if worst case scenario, there is a dispute about what to do with a student in terms of promotion or retention, there is a process in place that schools can follow, and so that everybody knows what to expect throughout this process. And with that, we are going to turn to this new Supreme Court case that came out yesterday.
All right. I see a few questions coming in. I tried to answer a few. Yes, this is being recorded. I linked, just flagging for you all our resources in the chat, and we will also send them to you via email when we send you this recording. And we'll keep putting questions in there, and we will get to those later. But I think it is certainly important to discuss the new decision from yesterday. So we're wrapping up that decision on the model policy on promotion or retention. And this is obviously a really key legal development, particularly with how Act 20 is funded and implemented. So as we noted yesterday, the Wisconsin Supreme Court issued a ruling clarifying the boundaries of the governor's partial veto power and the legislature's authority over appropriations related to Act 20. Lauren and I are going to briefly review this decision, explain its implication for school districts, and discuss how it might affect the practical rollout of reading programs and related supports. So the first thing, just to get to that background, Lauren, there were 3 laws that were passed that shaped the early literacy initiatives in Wisconsin: Act 19, Act 20, and Act 100. What are these 3 laws and why are they important?
Yeah, so if you haven't read our Act 20 legal explainer, which Corey has linked in the chat, and again, we will circulate after this webinar, Act 20 was a part actually of a group of 3 bills that were intended to improve early literacy outcomes. Act 20, and the reason we all refer to Act 20 as just Act 20, is because it created the reading and literacy improvement programs and requirements like the approved literacy curricula and materials, professional development for teachers and literacy coaches, etc. But then Act 19, which is actually the state budget bill, put a little over $200 million in the Joint Committee on Finance's supplemental funding account. And you'll hear me as we discuss this refer to that as JCF's funding account or supplemental funding account. And then in the JCF and the Legislative Bureau of Analyses earmarked $50 million to implement these programs and requirements. And then finally, Act 100 created separate accounts to hold and distribute those funds for specific purposes. So if you're confused, another way to think about this is Act 100 essentially created bank accounts. Act 19 put money in those accounts. And then Act 20 said what the money can be used for.
All right. And for anyone that was following this at the time, all 3 of these laws essentially passed with bipartisan support. They passed the Assembly, the Senate. There was support on both sides. So why is there a lawsuit? What happened that there was a legal battle?
So the legislature wrote Act 100, which again created those separate accounts and earmarked $50 million to be used for certain designated purposes with JCF approval. The legislature wrote Act 100 the way it did because it was concerned that if DPI had unfettered access to the $50 million, it would fund programs or initiatives that did not advance the purposes of Act 20 the way it was written, and that it was the legislature's role to set education policy for the state. And part of that role is to determine what literacy programs and requirements should be funded. So, with that background in mind, when Act 100 reached Tony Evers' desk, he exercised what's called a partial veto because he thought Act 100 was overly complicating the allocation of this funding related to literacy programs in Wisconsin, and that by consolidating all the funding into one account, the DPI would have the flexibility to utilize the appropriate amount of funding for various literacy needs. So, in other words, Evers took the legislature's purposeful separate accounts in Act 100 and consolidated them into one giant account for DPI to use.
All right, then expanding upon the partial veto power that you mentioned. For those who are not aware, this involves or allows vetoing parts of appropriation bills or bills that appropriate funds without rejecting the entire bill, without either signing it or rejecting it, vetoing it in whole. This is the partial veto power. So can you tell us a little bit more about what that is and why it was a key issue in this case?
Yeah, so kind of as you already mentioned, under the Wisconsin Constitution, Governor Evers has the power to partially veto certain bills by only vetoing certain parts or certain provisions of the bill rather than just vetoing the entire thing. However, this is a limited power as it's only available for use on appropriations bills. So, in general, an appropriations bill is a bill that authorizes government agencies to spend money for specific purposes. And importantly, the Supreme Court has held that a bill's interaction with, interplay between, or indirect bearing on an appropriation bill cannot transform a non-appropriation bill into an appropriation bill. To qualify as an appropriation bill, a bill must set aside public funds for a public purpose within its four corners. And so the Wisconsin legislature ultimately sued Governor Evers and claimed that the governor should not have been able to exercise this partial veto power in the first place, since Act 100 was only creating separate accounts for the money and not actually putting any money or setting aside any money in these accounts, and therefore it's not an appropriations bill.
Thank you. Now, turning to the actual outcome of the case, the legislature was successful in that challenge. The court concluded that Act 100, as you said, was not an appropriation bill because it did not directly set aside the funds. So the governor's partial veto was unconstitutional. Can you tell us what that means for the legal status of Act 100?
So the court ruled unanimously yesterday that because the governor's partial veto was unconstitutional, he can't partially veto a bill that's not an appropriations bill. Act 100 shall go into effect as the legislature originally wrote it. This means that the money shall be allocated into an account for literacy coaching and into an account for things like professional development training for educators and the approved literacy curriculum as it is requested by the DPI.
All right, and now a little bit more into the details. The legislature appropriated that $50 million to JCF, or the Joint Committee on Finance, in Act 19, with 50 million of that to go to supporting Act 20. JCF then has discretion over releasing those funds. The court ruled that the money can't be redirected by the governor or the courts to DPI. So what challenges does this create for DPI and school districts who want to use the funds?
As I kind of already alluded to, the legislator allocated over $200 million to JCF in the budget bill, which again was Act 19, with 50 million of that to go towards supporting Act 20. The legislature did not allocate 50 million to DPI to use to distribute in order to create a check system on what DPI is using that money for. JCF claims, and the Supreme Court agreed, that the legislature gave JCF the statutory discretion regarding whether to release the appropriated money from Act 19 to DPI. So this means that DPI will have to request the money from JCF, and JCF will approve that funding as needed. But DPI has decided that it wants all the $50 million right now, and that has been their request for the last 2 years. And you'll see on the screen here, I have the statement from back in 2024 when some of this was going on, that the state superintendent has been requesting that JCF release the funding, release the $49 million. But DPI this entire time has been asking for a lump sum, that $49 million, to be put into this bank account, quote unquote, that Tony Evers unlawfully created with his partial veto power. So the controversy over the last few years has been that JCF does not want to release a lump sum of $40 million into this account that was unlawfully created, and DPI is claiming that JCF is holding the funds hostage when in reality they just haven't been requesting the funding the way that the law was originally written to and the way that it was originally intended.
And just to clarify, I believe I said that there was 50 million allocated in Act 19. Listen to how Lauren said it. I should have said that the legislature allocated 200 million to JCF in Act 19, with 50 million of that going to support Act 20. So just wanted to clarify that. And I will too link the decision from yesterday for anyone that is very interested in reading more beyond this discussion we're having. So I'll put that in the chat and we'll send that to you as well via email. But now turning to kind of what does this mean? How does JCF's discretion affect the flow of funds and program implementation? I know that's a big question, but what do we know?
Yeah, so DPI and JCF clearly have different ideas about what this means, and we don't entirely know yet how this flow of funds is going to work. I will also say, though, that there was, and DPI talks about this in some of their original court filings, there was a request from DPI in November of 2023 for certain funds that JCF did approve, which is why we've been referring to 49 million as opposed to 50 million. A little bit of this money has already been distributed from JCF to DPI. And the DPI requested the funds the way that the law was originally supposed to work. So that money has been released, and we know that there is a process in place and that it does work because it's already happened. But the decision yesterday is a really great first step towards clearing up any uncertainty surrounding the funding for Act 20, but we don't have all the answers yet. Yesterday, the state superintendent, Jill Underly, released a press statement that she has submitted a plan to the Joint Committee on Finance, JCF, that gives a quote unquote roadmap on how this funding should be released. Conveniently, that plan was not linked in her press release, so we have not seen it. We have requested those plans from JCF and will provide any additional clarification when and if we can.
So given that uncertainty about the funding flow and veto authority, how can school districts, so we're talking to a lot of school board members and district administrators, how can they responsibly plan for their literacy program implementation?
So, another wrinkle that we really have yet to touch on, and it's a big one, is the fact that the budget cycle ends in 4 days. So, this means that any money in JCF's supplemental funding account that remains unspent will go back into the state surplus. Will connected with some legislatures yesterday to see if there was a plan in place to save this funding from going back into surplus. And we obviously don't have a definitive answer on that yet, but it does seem likely that JCF will adopt a motion to prevent the funds from reverting back to the general fund and instead keep them in the supplemental account. If this happens, there will be time for DPI and JCF to work together to fund these literacy coaches, curriculum, and professional development that's required under Act 20. But in the meantime, schools should try the best that they can to follow the statutes created under Act 20 to the best of their ability.
And then I think this is kind of the last thing we want to touch on before we open it up to answer the existing questions and do any more Q&A, but what communication or legal strategies should districts consider to ensure that they're complying with the law and using any available funds effectively?
So, this lawsuit really only affects the funding piece of Act 20. So schools should continue on complying with the law the way that they should have been throughout this school year and anticipate an update on the mechanics of the funding coming soon. But this means that schools should make sure that you're publishing the percentage of students reading at grade level by the end of third grade in your accountability report starting this year. You should be administering the universal screenings, diagnostic assessments, and fundamental skills assessments when they are required to be administered. You should place students who are considered at risk on personal reading plans. You should hire a reading specialist certified by the DPI to coordinate a comprehensive reading curriculum in grades kindergarten through 12. You should ensure each individual who teaches a class from kindergarten to third grade has received professional development training. And of course, the reason we are hosting this webinar today, you should ensure that you have a policy establishing criteria for the promotion and or retention of students in third grade who are on personal reading plans. So I believe with that, we will open it up for Q&A.
Yes, well, Lauren, if you want to take a look at what's in the chat, I will mention that there's obviously a lot in this law, a lot for you all to be aware of. If you have additional questions that come up and either you don't get to ask them today or you think of it later, you can feel free to reach out to us and we'll do our best to be a resource and help you navigate this. I also want to mention, I don't know that we shared this, but if you go to the will implementation guide, Lauren discussed that making this decision about whether to promote or retain should be dependent as much as possible on objective criteria and have a record too of what that criteria is and where the student falls on each of those categories. So we created a matrix. It's just a 1 page of all the different criteria. Does this criteria support promotion or retention? And then do you want to add any comments? So I just wanted to flag that as a resource you might want to use as well.
One of the questions in the Q&A is, does the district have to inform the school board of the number of students not being promoted to fifth grade? I assume you mean fourth grade. This is for a promotion policy from third grade to fourth grade. Um, there isn't anything in law that specifically says that any individual school has to report on the number of students who are not promoted, but there is a requirement that you have to publish the percentage of students who are reading at grade level by the end of third grade in your accountability report. Obviously, it's also best practice for communication in your district as you are working on ensuring you are in compliance with Act 20 and that your policy is working the way that it's supposed to, that schools communicate with their school board on how this is working actually on in the classroom level. Um,
I see one of the questions indicates the funding or the reimbursement. Which schools get that opportunity? Obviously, this bill concerned public schools, charter schools, and private schools participating in parental choice programs. I will note that there's language in Act 20 about the reimbursement that's available under the law. And it indicates that if the amount appropriated is insufficient to pay the full amount of that reimbursement, the department shall prorate the grant awards among all grant recipients. So that reimbursement amount is to be prorated by law. And I think it kind of remains to be seen exactly how that will be divvied up among in terms of the timeline of when schools apply for reimbursement. The types of schools, I don't know if we know exactly what that will look like yet, but I mean, it wouldn't hurt to kind of think about your budget as if you're not going to get the reimbursement if you're a private school. I just don't know. I think ideally that prorated amount you'll get some reimbursement. But we just don't exactly know what that will look like.
Another question is about whether parents have the final say in vetoing retention. So as I kind of mentioned as we were discussing the criteria that you should establish as you're considering the promotion or retention of a student, the state statute doesn't say a whole lot about what is required to be included in that criteria, but it does say that you have to establish a policy that specifies all of that criteria and that criteria will go into effect starting September 1st, 2027. And if a student isn't meeting that criteria, then they must be retained. That's why we have in our listed criteria in our model policy the opinions of the parents, the opinions of the teachers, test scores, how they're doing on their personal reading plan, any barriers that they have, among other things. But there is no statutory requirement that says that parents have to have the last say in promotion or retention. Again, this is also, it's a sensitive topic, right? Obviously, schools and parents are trying to do what's best for the student to ensure that they have the necessary building blocks to be able to read and to continue to be successful as they continue on in their education careers. But that's why we include this appeals process as well. So, if the school determines that it's appropriate for a child to be retained based on the criteria, based on the fact that the student has not completed their personal reading program, the parent still has an opportunity to appeal that decision to the school board if they really don't agree with it, and provide additional information on why the student should or shouldn't be promoted. Um, and we have that in place again because we know that this is a sensitive topic. We know that this is a sensitive issue. But retention, while it's not obviously the first choice in figuring out a way to improve early literacy, it is a tool for schools to ensure that students really have that good foundational early literacy um, basis before they continue on with their education. And as I mentioned, 17 states just flat out require it if students are not meeting certain proficiency levels on testing. And Wisconsin has allowed a little bit more flexibility. So I know that's a long answer to your question. The short answer is no, there is no requirement in state law, but I wanted to provide all of that additional information and background for you as well.
Yeah, and as individuals will see too, if they read that first page of our model policy, we really emphasize the involvement early and using these tools and these screeners and reading plans early, communicating with parents, because then ideally you won't see retention rates increase. That's not the goal of this. As Lauren had mentioned, it's a tool. There's research supporting it. But really, the hope is that with all of these other supports in place and policy measures in place, retention won't be necessary. There's a question in here.
I just typed an answer out, sorry.
Oh, you did good. Okay.
Yes.
Just for anyone who's listening, it had to do with like criteria, 14 criteria, but A to L. Lauren, I'm sorry, I didn't know what that was referring to.
So in our model policy, we have listed out the criteria. It's not numbered, it's lettered A through L. And A through L isn't 14. They were just confused about if there was any other criteria. And I just answered that some of the letters have more than one criteria to consider. So as I've mentioned, the opinions of the parents and of the teachers, those are that's considered like one letter, but it's multiple criteria. It's just, it has to do with the formatting of our model policy.
Okay. I don't see any other questions. We could give individuals just another minute or so if there are any. I'm trying to think if I had any final thoughts before we wrap up, but I think this is just overall, I'll mention that implementation of this law is something that will continues to monitor. And we're certainly following what this looks like. We're flagging, or I should say, we're receiving questions from school board members, private school leaders, and we want to be a resource for you all because Will supported this bill. We want a law in place. We think it's a good idea to have a law in place to support kids, to support reading in elementary education. And especially as a mom, I know how important it is, and we want to see all kids succeed. So we want to be a resource for you all. And with that, we will follow up with you all in an email for everyone who signed up today to get you the recording, to get you those resources. Lauren, anything else on your end?
I will just add that if you have any questions, don't hesitate to reach out to Corey and I. Our emails are on the screen there. And we really hope that you take all of our recommendations today back to your boards just to give you something to think about. Again, as Corey mentioned at the beginning of this presentation, we understand that you have to have a policy in place by July 1st. But as you review that policy, you can always add to it, add any of the best practices we talked about to ensure that these students really get that good foundational early literacy curriculum. And thank you all so much.